So thanks for being here. Welcome. I'm John Karpoff, and Scott Lee, Jerry Martin, and I have written a couple papers on financial misconduct. We've been talking about some of these issues for a long time, and we'd like to share some of the thoughts that we have about doing research in this area. A couple of, I guess, qualifying remarks. We're not going to try to summarize research findings in this area. Rather, we're going to be talking about doing research in the area. So let's get going. So first, why do we do research in financial misconduct? I'm going to propose there are 4 reasons. And the first is simply that it's fun. Everybody likes a good crime story. We have movies. We have a whole industry about books that tell about crime stories. And so in our own research, crimes and punishment are a big deal and just intrinsically fun. It did work. Another reason why there's a spate of new research in this area is that there's a lot of new data available and relatively easy ways of compiling samples of firms or individuals involved in misconduct. Here's a list of just some of the most popular databases. There are a lot of good research opportunities. I realize there are a lot of words on this slide. I'm actually going to read some of these. These are just my top 10 research questions. You may have your own. There are many more here. What's the probability of getting caught? This is a large, big issue. What's the cost of fraud? How is it best deterred? How is financial misconduct disciplined and deterred around the world? How well do markets discipline fraud? What's the right amount of regulatory enforcement? Why do managers lie, cheat, and steal, given the large penalties that have been documented? How do macroeconomic conditions affect financial reporting misconduct? We have several papers in the literature about that. How do reputational and cultural enforcement interact with public and private enforcement? Is there a relation between expected returns and the probability of financial reporting misconduct? Given replicability issues that I'll talk about in a minute, how robust our current understanding is our current understanding of many issues in this area? So there are many more, but compared to other areas of research in our field, there are still relatively low-hanging fruit in this area. There's still big questions to address, not little marginal things. There are a lot of little marginal things too, but there's still a lot of big things to address. I think that's one reason we're seeing a lot of research in this area. And number 4, which I'm going to spend some time on, my 4th reason why I think there's so much interest in this area and so much work being done in this area is that it gets to some of the core issues in economics and finance. Now, in thinking about core issues, if you were to think of like one-word answers to, what's central to our understanding of economics and finance? Economics is the study of exchange and production activity amid scarcity. Finance is its application to certain areas of the economy. What's core? What's central to our paradigm and our models, our understanding of the world? Well, you might say valuation is really key. Certainly when I teach, that's a real central organizing notion. Contracting. We had Oliver Hart here yesterday. Pricing, rationality, the quest for allocative efficiency, the role of markets. I think all of these are central core organizing concepts in our field. And I want to propose one that is really also related to many of these and that lies at the heart of things, and that's just the role of trust. Again, if we are an applied area of the study of exchange and production activity amidst scarcity, without such exchange and collaborative productive activity, we would live in worlds of autarky. And without trust between counterparties, you wouldn't see much exchange and production activity. If something as mundane as going to the store to buy an apple, I have to trust the hundreds, thousands of people in the supply chain that I don't know, so that when I show up at the store to buy an apple, there is an apple there. And even more amazing, that I won't get poisoned, that it might even taste good. There's several leaps of trust that happen in such simple transactions. Rarely is trust so evident in these sorts of transactions, so transparent, as in financial transactions. When I fork over some money to be managed by somebody else, or to invest in an enterprise where day-to-day operations and control are exercised by other people, that is a leap of trust. And that lies at the center and at the core of a lot of what we examine. Now, going back to the days of Adam Smith even, this clicker is selective in its use. There we go. the central organizing role of trust has just been baked into our models and our understanding. We have a lot of theoretical literature. Again, Oliver yesterday, Jean Tirole won the Nobel a couple of years ago. A lot of his work has to do with the theoretical understanding and the role of trust in contracting. But we have relatively little empirical work in this area. I think, and I'm going to propose, that research into financial misconduct provides an unusual opportunity to apply empirical techniques to gain some understanding on the role of trust and where it applies, where it's big, and what causes its breakdown. Now, this is a bit corny, but I'm going to propose something. So you're probably, if you're in this session, you're probably familiar with the fraud triangle, the notion that you've got to have opportunities, incentive, and rationalization for fraud to occur. It's a popular concept among practitioners and enforcement regulators. So sort of trying to mimic that sort of gimmicky approach to things, I'm proposing that there's a way to organize our thinking about how trust arises, how it's enforced, using 3 different areas. And the first is third-party enforcement. One thing that encourages me to trust that apple that I'm going to get is not poison is I know that the people who are selling me that apple don't want to go to jail. So there's a sort of third-party enforcement. And we have a lot of literature devoted to this. There's a lot of law literature devoted to financial fraud, for example. And then in our area, the law and finance literature has really begun to explore this and many of these issues. There's related or second-party enforcement. This is related to work that Scott and Jerry and I have been trying to do, and that's just the role of reputation and the role of repeat contracting in encouraging people to deliver honestly and truthfully on their side of contracts. So another reason that I trust that my apple is going to be good and tasty is that I know that the store owner wants me to come back and buy again. And there's also first-party enforcement. That is self-discipline, self-values, ethics, cultural norms that encourage individuals to act well on their side of transactions, exchange and production activity, without the threat of repeat dealing or the threat of outside enforcement. So this is a big new area. Other fields have explored how culture plays a role in what they're doing. Here in finance, we have this new movement to explore the role of culture just within the last several years. So our challenge as empirical researchers, if this is something that is central that we want to try to address, is that we have all these models that tell us that trust is really important. But we really have very little, again, empirical work because it's really hard to measure stores or quantities of something like trust or reputation. Now, people try. In other fields, people have been trying for a while. In finance, corporate finance especially, we see more recent attempts to use reputation indices or environmental, social, governmental measures, surveys of, say, employees to get measures of high trust companies. Text analyses are becoming increasingly popular. But as valiant as these efforts are, these are really still poor measures of trust and reputation. It's like trust is our dark matter in the world of physics. We think it's important. We have models built on much of our understanding of exchange and production activity is built on this, but we don't have good measures of it. It should be there. We just can't see it a lot of the times. Just like we think dark matter is holding the universe together. It's got to be there for our understanding of the physical universe to make sense. However, although we can't observe trust and reputation directly, we can observe changes. So we can observe breakdowns of trust through the occurrence of fraud and misconduct. That's why I think fraud and misconduct empirical research has this unusual opportunity to say something about bigger fundamental issues in the world of economics and finance. So it's analogous to inferring the existence of dark matter from its gravitational effect on things. There's a quote I have here from a well-known physicist that says, if you cannot see dark matter, look at its effect. That's sort of what we're doing in fraud research. I have a few more comments I'd like to I'd like to go from that sort of big metaphysical kind of issue down into the weeds by talking about some data issues. So this is something that is near and dear to Scott, Jerry, and me. And I'm going to tee up some of the issues and then turn things over to Scott and Jerry. So let me go back to this issue of there's a lot of research in this area because there are a lot of data. It's really good, but it turns out that the data source matters. And let me give you a couple of examples. So let's say you wanted to know whether operating performance is higher or lower while firms are cooking books. We have some stories in the literature where earnings would be higher while firms are cooking the books, some which they'd be lower while they're cooking the books. And what we've done here is report using events drawn from 4 different databases. Here I only have 3 because the GEO restatement database doesn't have information on while firms are cooking books. And we've done simple first difference test. We've measured ROA in the years that, according to the database, firms are in violation of some financial reporting rules. And the 3 databases are Audit Analytics, the Stanford Securities Class Action, and the AAERs that are available at Berkeley's Center for Financial Reporting and Management Research. CFR. They're AAERs. And you can see that if you used, say, the first 2 of those data sources and just drew events from them and did this first difference test, you would infer that return on assets are relatively low while firms are cooking the books. If you do the same experiment, everything's the same, just drawing your sample from a different source, in this case, the AER database, you get the opposite inference, just from changing the data and the data source. Or let's say this one, how about do firms repurchase more or less while cooking books? We have stories about this related to the windows of opportunity hypothesis. And here, again, you see mixed results depending on the proxy that you use for misconduct and the particular database that you use to draw your sample. Here, it's the Audit Analytics one that is the outlier compared to the other 2, which show results go the other way. How about if we're looking at before-after test relative to the revelation of misconduct, using the events and the dates associated with these events that are used as proxies for misconduct from now all 4 databases, because we can use the GAO restatement database here too. And let's say you're looking at CapEx. Does it decrease after misconduct is discovered? And again, we have stories in the literature, theoretical models that make some suggestions one way or the other. And here you get some results from the GAO restatements or the Stanford Securities Class Action lawsuits that suggest that, in fact, CapEx does decrease. So while firms are cooking the books, they're also over-investing. Is the inference you would draw from this simple first difference test using these 2. Using restatements from a different database or using AAERs as your proxy for misconduct, you don't get significant results. So we, and I should say especially Jerry, have looked at this kind of test for a lot of different outcome variables. And we're seeing this kind of pattern frequently arise. It's simply plugging in a different proxy and a different source of data for your events. You're getting different results that start to get squirrely and all over the place. That's what this says, that many results are sensitive to simply the choice of proxy and this choice of data to identify or compile a sample of misconduct events. In the simple test we've done, we found that you replicate one result by choosing a different database 42% of the time, which means you don't replicate 58% of the time. We've just, again, done this with a relatively small number of outcome variables, looking at these 4 different databases. Now, replication studies have become popular in other areas, and in these other areas, we're seeing replication rates of, say, around 40 to 67%. And this has caused a lot of consternation in other areas, a lot of soul searching about implicit research bias, source of data, tainted tests, things like that. In our area, we also are concerned about replicability and the ability to develop some confidence in our empirical results. In this one area, we're seeing replication rates that are also very low, but in this case, solely due to just different choices of data for your inputs. Now, there are a couple of reasons. Scott's going to elaborate on this, I believe. One of the reasons is simply that the 4 different databases I was using in the previous slides don't overlap as much as we think. So they're actually identifying different instances of misconduct. This is a not drawn to scale attempt to represent the non-overlapping based nature of these various databases. Another and more fundamental reason, though, that I want to point to has to do with, there we go, an issue that I have a couple of slides that we have put together to try to illustrate some of this. So the way I think about this is that, as researchers, we really work hard, we train hard, and we sweat the details about a lot of details. We want to get our theory right. We want to get our identification right. We want to get our statistical techniques right. I propose that we really also want to get our data right. And it's not simply a matter of errors of commission or omission. All databases are messy, and all empirical work is, when you're not simply spinning some tape of well-established data, especially if you're compiling stuff on your own, it's going to be really messy. Or if you're starting with a database and then trying to work with it and clean it, it's always really messy. So that's not what I'm talking about. I'm talking about a different source of concern here, and that is, it's just that these events that go into test that examine various things about financial misconduct are drawing data from this really complex institutional environment. And to some extent, I may be like, it's like a new convert. I'm extremely enthused about this, and maybe many of you already know this. But for me, and I think for the way I've heard you and you talk about Scott and Jerry, also, it's been this discovery process about how complex this is and how this affects fundamental things we do in empirical research. And it also helps explain why different data sources get different results. Now, to explain or illustrate what I mean by this, what I have is a timeline here of different informational events related to one instance of misconduct. This is computer associates fraud. This is a well-known fraud where they're cooking books, and it played out in the press quite a bit. So it's possible to identify 41 distinct key incremental informational events that reveal information about the likelihood of misconduct, the full extent of the misconduct, the nature of the conduct, and the consequences to the firm and individuals involved for being involved in the misconduct. And these include 4 press announcements that are associated with 8K filings, 8 earnings restatements, class action filing, settlement, and 27 different regulatory actions, that is administrative proceedings or litigation releases from the SEC. It could also include DOJ and other regulatory announcements. Some of those regulatory actions from the SEC also receive a secondary designation as an AAAER, that is Accounting and Auditing Enforcement Release, which is sometimes a proxy, very frequently a proxy that is used to identify misconduct events. So there's a lot of stuff, and look how long it plays out. This plays out over 15 years. Well, let's say I access this event from the GAO's restatement database, which has been for a while a popular source of information about misconduct or things that we think might be misconduct because they're about restatements. Well, it turns out that you would identify 7 of the restatements, so most of the restatements associated with this instance of misconduct, plus one other one that's unrelated to computer associates misconduct. So you identified some, but only a small subset of the full sequence of informational events that are important for understanding, categorizing, coding your instance of misconduct. How about audit analytics? Even though audit analytics has a lot more restatement apparently in its database, in this case it only captures 4 of the restatements. But if you use the Stanford database for securities class actions, you identify one of the key events, the filing of the class action. And if you use this popular database on the AERs, you'd identify 10 of the 12 AERs. But again, only a small number of the regulatory releases that provide the narrative about what's going on, in this case of misconduct. So in each of these cases, the good news is that all 4 of these do identify this instance of misconduct. That's actually unusual that all 4 overlap like that. But even here, you're only in each case getting a slice of the total picture. It's not a problem of the databases themselves. It's a problem in that the world is just really complex. This instance of misconduct plays out over more than a decade. And we as researchers want to use some of the information about this as inputs for our tests. So at the risk of being offensive, it's as if you use any one source, any one proxy, what you're doing is you're feeling only one part of this big elephant, this classic blind man and the elephant story. So if you're accessing only AERs, you think, oh, this is a case of misconduct that had this violation period. It was released and revealed over here. And if you use a Stanford database, they'll say, oh no, the violation happened during this period, and people found out about it here. And oh, look, we didn't know that it also had all these other things that are associated, these other fraud charges. You might not even classify it as fraud in some cases. So that's what I want to leave you with. If I were to go back to a motivation for why I'm enthused about research in this area, why we would like to see more go on in this area, it comes back to this idea of there's a lot of low-hanging fruits, a lot of really interesting central key questions, especially compared to some other areas in our field. There's a lot to be done here.
I'm not going to talk that much about this. I just want to, and I don't want to promote what we did, I just want to use it as an example of troubles you run into with going into this area and how difficult it is to understand these things. I mean, juries often ask for data, and people don't understand what they want the data for, is kind of our impression of it. A lot of times they think a fraud's a fraud, blah, blah, blah. And we know, for example, here, it's commonly pointed out, we knew this going into the thing, that we're just looking at the tip of the iceberg. It's really, we're reliant on the regulatory agencies to create some information about this and for us to go into this. And so, it's a standard, I don't know, what's the standard ratio of the iceberg? It's 1 to 8 or something like that. At any rate, we're looking at a very small portion of it. We know that. At some point, maybe somebody can figure out something more of that. We have talked a lot about that, but it's not easy to do. The thing that is startling to me, in retrospect, is how little we know about the tip of the iceberg, even having spent time looking at the iceberg. So kind of the state of the art when we got into this stuff was that people were using broad terms like accounting fraud. And there's even different types of accounting fraud. What we're focused on in our case we call financial misrepresentation, or what we'd call cooking the books. There's other forms of that. There's lots of other different types of fraud. John's looked at environmental fraud with some of his colleagues and things like that. Lots of different things you can get into. But generally speaking, in this area, what people were doing is they were looking at either accounting and auditing enforcement releases, which stems back to when these things were first described in I think it was a JFE paper, JAE paper, doesn't it? At any rate, they had a conference and it was presented in Rochester, and that sprung forth a lot of research in that area. There's also been a lot of work with restatements that also coincide with this. And I'll note that when John put this up, you would have noted, if you were looking, that there's lots and lots of restatements. There's lots and lots of security class action lawsuits. And so there's lots of ways to map this onto accounting fraud. And so kind of the question is, what's it look like when you actually do that? And so Are there some restatements that have nothing to do with accounting fraud? Are there some securities class action lawsuits that have nothing to do with accounting fraud? Are there some AERs that have nothing to do with that? Well, the answer is yes. And the question is how many? How many do you have to cull out if you go into that area? What kind of an overlap do you have here? And a lot of what we think about with this, I think a lot of what, let me personalize it, a lot of what I thought initially when I got into it was, well, if you can just get a toehold in here, what you can do is you can get one of these announcements, and then you can look a couple of years forward, a couple of years back for announcements that are going to kind of give you the whole story. You know, so John's kind of stolen the thunder on that by saying it's a long period of time, a couple of years, plus and minus ain't going to catch it. So we know that, but let's look at this a little further. So, oh, here's my 70%. So only portions of these populations are going to be available. We know that in the tip of the iceberg sense, that we're only going to catch the ones that are caught, at least from our perspective. We haven't figured the other part out yet, or we can get to the stuff that's below the surface. And so what Jerry worked into was by looking at the Foreign Corrupt Practices Act, he learned that the 13 Bs were at the kind of the backbone of this, and learned the regulations that were associated with it. And so that's become our sample frame to look at this. And so I'm going to look at it from that perspective to give you an idea about this, what happens. The restatements, we've got another problem. Either you're going to have to go out and find restatements yourself, or you're going to be reliant on some other database to provide you those. And so there's a couple of restatement databases. The GAO, which is effectively dead now, it was only over a few years, about a 10-year period. And then the Audit Analytics, that is a live database, it's getting updated all the time. And then the securities class action lawsuits is done by the Stanford people. Harold Grunfist out at Stanford started that up. Did I get that right, Harold? Joe Grunfist, sorry. And then AERs, and then there's the DGLS database that out of Berkeley that John mentioned for that. So that doesn't mean you're getting all of those, but that's a source of data for these things. So this is kind of my conception of what I thought when I first got into this. That, okay, there's going to be, and I think it's a reasonable conception of what most people think is if you can do this, then there's a lot of commonality here. And you can basically get in here, and so the sample frame here is the tip of the iceberg, which we're defining with the 13 Bs. And so you'd get a large portion of these, and so you're going to do fine. Okay? Now, in reality, and this is not to scale, because I don't know how to make it to scale, but I tried to make it to rough scale. For the 1,243 13B violations that were enforced, the enforcement action up through August 19th of 2015, this is what we're looking at. We're looking at a sample frame here that's defined by the black square, okay? And we're seeing, here's the AERs, here's the AAs, the accounting analytics, the SCAC, which is the Stanford Clearinghouse, and then GAO. Now, let me put some numbers on this. Out of these, the CFRM database, the AERs capture, the database of AERs captures 53% of these. Pretty good. Maybe not as good as people might have thought, but pretty good. Not as good as I would have thought. The SCAC captures 31% of those. The Audit Analytics captures 30% of those. Now let me stop and mention, this number, if you look at this, the 375 doesn't coincide with what John put up earlier, which was, I think it's 5,000 or something like that, I can't remember. It's a lot of them. That's because there's a lot of restatements that have nothing to do with this. And so that's one of the problems you face using that database. You've got to cull those unrelated ones out. And so the GAO, finally we get down to 22%, And in this area here, I don't think that's probably to scale, is about 11% of those that you actually have something like the Computer Associates one, which was, it's not uncommon in terms of the length of it and that sort of thing, the type of things that were happening with it. It's uncommon in the sense that only about 1 out of 10 actually have all of these characteristics with them, that they would be captured by all 4 of these databases. Okay, so it's not what I thought going into it, that you're going to be able to capture it no matter what approach you take in terms of database. There's 1 in 3, 36% of these things are captured by any of those 4 databases. Okay. The other thing that I just want to point out, and this is the last thing I want to point out, is just the thing that John's already brought up, and it's startling, I think, is just how complex these things are. And this is not, it's not to say that everyone is this complex, but this is typical. Okay? This is typical. This is kind of the centrality of the distribution. It can be a lot more. But basically, you're looking at an enforcement period that's about 4.5 years. Okay? And so from the time of the initial announcement, which a lot of people like to use to see an effect, see what the announcement effect was. Well, based on what you were using, if we went back to John's slide, you're going to capture an announcement effect that's anywhere along up and down that line depending on the database that you get. And so that's a lot of the reason that people get different estimations on the response to that. And we feel like basically all this information is important. All of it reveals a little more about it as it goes along. The other thing that I see a lot is that people like to do these things where they look at abnormal returns and they'll do estimation periods from the pre-event period. And so they'll maybe use from day 250 to day minus 250 to minus 30. And if you're picking something in here, you're using an estimation period that's pretty contaminated. And so personally, I think that just looking at a market adjusted return is smarter in that case than to go in and try to do risk adjustment, because you're picking up all kinds of stuff if you do otherwise. The other thing that happens here is the violation period here. There's a lot going on beforehand on average, a couple of years beforehand. And so it's not like your mother's or your what's the commercial. It's not like your father's Cadillac kind of thing, or I don't know what that was, but it's not like your father's event study. And we found that out when we did the study to see if CEOs got canned after they got in trouble with this. Basically, what happened was we were trying to do a standard Warner Watts Ruck type announcement effect and see, when this is announced, what happens to these guys? We found out about half of them had been pushed out of the firm by the firm before this ever even hit the market. And so it's real different in this sense. I think what we found, what I got to say Jerry has found, I got to give him, I think, most of the credit, is that you have to go in here and you have to go and look at this and understand what John said this, what the institutional details are, what the regulatory details are that cause things to happen. I mean, for example, why don't more of these things have restatements? Well, if you think about it, it's, I think, fairly logical that if I was cooking the books, the last thing I'd want to do is wave a red flag by generating a restatement that says, hey, look at what's going on over here. And so I think there's actually disincentives for managers in those situations to do restatements. It's not to say they don't happen, but it's just say it's not clear that it's going to happen all the time. And in fact, our data says it only happens happens less than half the time, a little less than half the time. Kind of the same thing with class action lawsuits. There are rules in place that say that they can't file a lawsuit. They don't have a private right of action in a lot of these cases. And so what's going to happen is they simply can't, whether the lawyers would like to or not. And so you have to understand those details. AERs have a problem too, in that they are generally, I think this is appropriate to say, I mean, they're going to happen towards the end of this street, where the accountants are being, you know, here's the sentences that the accountant that was associated with this is going to get. And so they tend to happen out here towards the end of this. And if you look plus and minus 2 years, you know, you may end up thinking that your first announcement that you're looking at is here somewhere in the middle of the stream. So there's a lot of those sorts of things. That's just associated with this type of study. If you want to study insider trading, there's a different iceberg. If you want to study misreporting, you know, in the sense of there's a different rule for misreporting versus misrepresentation, that's a different iceberg. And so I think it's just very important as you go into this to do a lot of background research on the rules, the specific rules that are associated with it, to try to help you figure out what your sample frame is.
Well, I feel like in John's and Scott's vernacular, I'm the gardener of the weeds. So I spend all my time actually in the weeds, and what I want to do today is share with you a little bit of the knowledge that I've gathered through the years in working with this data, and hopefully help you in pursuing any type of research in this area. First of all, you know, we do have all these different databases that are available, and it's you have to really decide what is appropriate in the circumstance I want to use it in, within the sample framework that I need to design. What you really need to do is understand and recognize the limitations of the data source that you're using. If, for instance, you're trying to use restatements to identify fraud, you're going to have to do a lot of work. One of the reasons, as Scott pointed out, why would you as a manager, if you're engaging in this kind of misconduct, why would you want to even call attention to it by restating? I can almost guarantee you the regulator is going to look at a restatement, at least examine and analyze a restatement, the reasons behind it, if you were to issue a restatement. And so why would you even call attention to it? And it just so happens that in our data, only about, or actually less than 50% of the enforcement actions have a related restatement, but it's not just simply the manager's choice. Some of the reasons are, some of these firms are in distress. That's some of the reasons why they engage in the fraud in the first place. And by the time the public becomes aware, or the investing public becomes aware, the firm's no longer in existence. And so why would you restate? So there are other institutional reasons why we don't see much overlap in these data sources. If you do use restatements, you know, which is maybe an early signal of these things to happen, but it's again, the firm's going to have to survive. The firm's going to have to be probably governed in a fashion that we would like to see, because restatement may actually be a good governance indicator. You're going to have to probably look at filters for the restatements, because there's thousands, literally thousands of restatements that you can get out of the audit analytics data source. They only have 150 flagged as fraudulent. 150 out of their thousands. So you're now going to have to actually apply your own filters to that. Hensley and Miller, you know, did an admirable job looking at the GAO data and doing the errors versus irregularities. And they came up with a list of criteria that they used to try to ferret intentional fraud out versus just simple irregularities. Now one of the big catchwords, big R restatements now that have been working with some of the auditors and things like that. Even a big R restatement doesn't necessarily indicate that there's fraud. But I can see some people using, oh, if it's a big R, we're going to use the big R restatement. Class action lawsuits is one of my favorites to look at, and one of the reasons why you've got to understand what are the natures of private actions. And most of us think of class actions as being the only vehicle for private actions, and they're not. The other issues are the private plaintiff bar can't even bring actions against certain securities laws. For instance, 17A, which is basically fraud in the issuance of securities. Only regulators can bring charges under those laws, as well as, of course, financial misrepresentation under the Foreign Corrupt Practices Act, 13B. Only financial regulators have the power or the right to bring actions. It cannot be brought in a civil case or in a private civil case or class action case. So what they have to do is they have to prove it under the other statutes. They have to prove it under typically a 10B or 10B or 11B statutes. The other things about class actions is you've got to understand the motivations behind it. You know, why are they filed in the first place? Who files them? And what is the process that occurs during the class action settlement process, basically? Because almost all of these are settled. And why are all these settled? Well, they're settled basically because there's a D&O insurance providing the incentives for that to happen. If you don't settle and you go in front of, and you get adjudicated, go in front of the case, there's an exclusionary provision in your D&O insurance that says we don't have to pay. And there's also other clauses, such as the consent to settle and hammer clauses in the DO that basically says, if you have a hammer clause in it that says we have the right to force you to settle and not fight. And that's entirely left up to the insurer. And so the insurer gets involved in the negotiation of a lot of these settlements. And if you read the documents, they're going to say, we come to this settlement without any admission of guilt. And so we really don't know the whole story. It's motivated by a plaintiff bar that, of course, is looking out for economic reasons. They will file they are continually, I work with them in DC all the time. They're continually monitoring news stories, looking for an event that might cause a negative effect to a firm. They will immediately run down to the court, file the action, and they're going out and trying to find a client to represent. And when they find the client to represent, if they can prove that, or if they feel that they can meet the hurdles for burden of proof that they'll need to do, then they'll may get it certified. If other investors are involved, they may not. It may get dismissed early. It may later on actually go into discovery, and then even in the discovery phase, it may, all of this time, the insurers are behind the scenes working at settling this thing. And so it's not that there's not misconduct there. It's just we don't have a good picture of what that misconduct is. And we have other influences outside that may be driving the instances of a class action. And furthermore, we don't know if that class action, is it really due to specifics of the firm or specifics of a particular manager cooking the books, or is it due to other potentially related or other things? Maybe the manager at the same time was insider trading. He was cooking the books, forcing it up, trading the stock. So, and the other thing finally is that there are many other private actions, state, class, and derivative actions, district court derivative actions. These are typically not covered in the standard databases. It's not covered in the SCAC database, for instance. AARs, very popular source, more at the heart of the matter as far as 13B reporting. Urge people, if they're looking into using AARs, go back to the very first one. It describes what AARs initially were going to do. And they're also, because they are actions that the SEC feels are important to the accounting and auditing profession, they're basically going to be dealing with enforcement actions that involve an accountant or an auditor. Well, you can have misrepresentation without the accountant and auditor being culpable in the process. And if they're not, if it's just the managers, you might miss some of the most egregious frauds.
Just specify, the way you said that, it sounded almost like you were saying go back to the firm's first AAR.
No, I'm sorry, go back to AAR 1 to read exactly why AARs, what the purpose of AARs. I'm sorry, thank you, Scott. Just out of the 13B data that we have, 79%, only 79% of the enforcement actions for financial misrepresentation have at least one proceeding that has an AAR associated with it. So you'll miss 21% of them focusing on AARs, and that's within the AAR time frame. The 13B time frame is a little bit larger than the AAR time frame. Captures only a portion of the enforcement action. If you look at just AARs are typically only have one of the 10 proceedings that will occur in the enforcement action. The other 9 will have pertinent information, and many times much more information that's relevant to your question of study than just the AAR. And oftentimes we see, or I see, people that focus on AAR say, well, this AAR doesn't give me information about when the fraud took place, so it gets filtered out. Well, if you looked at the other associated enforcement actions, you could get that detail. Finally, the AARs will really only deal with SEC enforcement actions. They have nothing to do with DOJ, nothing to do with other regulators as well. Other regulators, as far as in the 13B data, 10% of the enforcement actions have a regulator other than the SEC and DOJ involved as well. I'll mention some of those in a second. Looking at the regulatory enforcement actions, stuff like the 13B data, there's still issues in that area. Some regulators have legal limitations, statute of limitations, statute of repose. They also have the decision whether or not to bring an enforcement action. They may decide for some reason that either the burdens of proof of the hurdles that they have to overcome to prove a case may not be worth pursuing. And therefore we may have an instance of fraud maybe that a restatement might catch or a class action might catch, but the regulators decide to pass. Evidentiary standards, burdens of proof is a big one. Depending on whether it's just a simple civil administrative action, a civil lawsuit in a district court, or a criminal action. So it really depends on the type of conduct. They also have choices of who to actually file against. They can file against the individual managers, or they can file against the firm, or both, or even other agents of the firm. Maybe suppliers of the firm. Kmart is was a good example in which there were 10 suppliers that were named as part of the action because they were signing off confirmation letters about rebates. And so Frito-Lay, Pepsi, some of these large companies were implicated simply because one of their managers signed these audit letters for the Kmart enforcement or misrepresentation, you'd say. And so a lot of people will go into these regulatory actions trying to find a company, a firm. And if they can't identify the firm, it gets tossed out. And so what you really need to do is look at the types of enforcement actions and then try to piece the things together. So, some of the tips that I want to leave you with. Try to understand the data generation process, or what we sometimes call the selection issues. We really have a double hurdle here in certain situations. And the hurdle is, one, the firm has to choose to engage in this misconduct. And secondly, the prosecutors have to also choose to enforce. So we don't know, if we have a regulatory enforcement action, obviously both of those things have had to occur. But we don't know for those that don't occur, was it due to the fact that the firm elected not to do it, or maybe it was the prosecutor elected not to proceed in enforcing. So an additional thing that I don't think many people are aware of. Also, just in the data that I've developed over the 20 years associated with 13B enforcement actions, there's at least 20 other regulators that have been involved in enforcement proceedings as well. And so if you're trying to find what the overall impact of the underlying misconduct was, you also need to look at potential the other regulators too, when they're going to start finding it. For instance, Treasury has been very active in these latest rounds of enforcement actions that have to do with the financial crisis. And so we get the FinCEN, the Office of Thrift Supervision, and the Office of Comptroller of Currency involved. And some of their fines are huge. The SEC may only have an administrative action and may not fine it, because the fine actually is being paid through the other regulator. One of the things that took me a while to learn and understand, the laws or the violations that are alleged in the cases or administrative actions are very informative about what goes on, just the laws. The particular rules, the U.S. Code and the Code of Federal Regulations. For instance, misrepresentation is going to be you're going to see a 13B or in criminal vernacular 78MB. If you were interested in reporting violations, misrepresentation, what we mean by misrepresentation is that the numbers were actually misrepresented. The numbers that were presented in the 10Q, 10K, or some other release or some other disclosure by the firm was in error. What we mean by misreporting is that the numbers were presented right, but the information around the numbers may be misrepresented. A firm may, for instance, a manager may change his inventory valuation methods and book those book it to earnings to show an increase in earnings. Well, if he fails to mention that that's what they did, that the increase in earnings was due to the change of accounting valuation, inventory valuation methods, that's a misreporting violation. The numbers are correct. It's just that the information surrounding those numbers is misrepresented. And so that's a misreporting violation. Fraud is a pretty wide net. Fraud can either occur in the issuance of securities or in the secondary market, or what we call fraud on the market, 10B. The rules, and it covers things like insider trading as well. Rules can really tell you a lot, the associated rules will tell you where the violation actually took place. Did it take place in a 10K? Did it take place in a 10Q? Did it take place in a periodic 8K report? And so we can actually, by just examining the rules, we can get a broad picture of what went on. The rules and the laws generated.
By examining the rules that are cited in enforcement releases.
That's correct. In enforcement releases, in the indictments, in the complaints, in the informations, anything that is associated documentation with an enforcement action. And believe me, there's going to be volumes of that stuff, and it does feel like going through the weeds sometimes. Apply your filters judiciously and very carefully. One of the things that I've shown, and a lot of few people have opened their eyes on and said, well, one of the things that we have to get other data a lot of times when we get into these enforcement actions. So we commonly merge them with CRISP and CompuStat so we can get the financial data, either the returns or some of the basic financial data we need to perform our analysis. Well, when that happens, we're now limited to the firms that also appear in CRISP and CompuStat. And we might come to the conclusion then that the SEC only, or DOJ or both, only go after large firms. Well, we've essentially filtered out all the small ones simply by our merging process. And there's quite a few small firms that are not covered by CRISP and CompuStat that regulators do pursue. Some laws cast a wide net. 13A, which if you're interested in misreporting, that is the quality of your financial statements, then you'd probably look at 13A. But however, 13A is also used for failure to report, failure to file your 10K, 10Q, and which most of the time leads to some revocation of the firm's securities. And so that's not really a misreporting that we might be interested in. It's just simply an enforcement action taken for failure to file. Fraud's used for a lot of different things. And one, for instance, is most popular use is, I won't say most popular, but a very popular use is insider trading. There is no law specifically targeted for insider trading, so it has to be prosecuted under the fraud statutes, under 10b, 10b-5, Rule 10b-5. Finally, don't ignore some of the resources that are available out there by the SEC and DOJ. The SEC has a really good website on the Division of Enforcement, and at that website you can actually get the SEC Enforcement Act manual. It's quite a long, detailed manual. It explains the process that they go through, the initiation of an enforcement matter, the standards that they have to go through to investigate, when they will bring in the DOJ, what is the Wells process, what is the Wells notice, who actually decides to bring the enforcement action, the votes of the commissioners and things like that. And so there's a lot of detail, institutional detail, in that SEC enforcement manual that can help you and guide you in your research quest. DOJ fraud section, DOJ is a little harder, a little more opaque than the SEC, but still there is some information there. As well as the U.S. sentencing guidelines. That can really tell you what are the factors that are considered when meting out penalties, both in incarceration of individuals as well as fines against the firm. And a few years back, the SEC and DOJ jointly put out an FCPA resource guide that you can get from either the DOJ or the SEC. It's the same guide that explains specifically the areas that we've been involved in, and that's the bribery and the reporting books and records, internal controls things. But it's not just bribery. It's the SCP, the 13B rule was put into place because of the Foreign Corrupt Practices Act. Many initially thought that it was due for the enforcement of bribery, but it has been used much more effectively in the enforcement of the accounting misrepresentation than it has in bribery. And so, in fact, for bribery, they've enforced about 170 enforcement actions under the bribery provisions. Under the accounting provisions, it has nothing to do with bribery. There's about 1,500 now. So you can see that it was a hammer that was actually used quite well once it was passed. So with that, questions, comments?